School of Law and Legal Ethics. When I started as an articling student back in 1987 or whatever in a big law firm in Toronto, one of the senior lawyers in this big firm always liked to impress upon us the importance of legal ethics. He used to tell the same story of a senior partner at a competing law firm in Toronto, another big law firm, and that senior partner had a client, a very wealthy client, who had overpaid his bill many times over, and there was very little likelihood that the client was ever going to realize that he'd done that. And this lawyer at our firm used to say this posed a real ethical dilemma for that partner, and the ethical dilemma was whether to tell his partners or not. Now, today we're lucky to have two fine speakers. Our first speaker is Professor Reid Mortensen. A good few number of you in the room already know Reid very well. Reid is a friend of mine, and he's a former colleague of mine and a number of people in the room, a UQ graduate, and for many of us it was very sad when Reid left UQ to go to USQ. It's sad that we lost him, but Professor Mortensen is an outstanding, eminent scholar, and one of his main interests, at least a main interest, is in the area of legal ethics. So I think I will start by inviting Professor Mortensen to speak first on this third session.
Thank you, Jim. Anyone who reads The Australian would appreciate that there could be some nervousness in being introduced by Jim. But thank you for your kind words. Judges have an ethic. My apologies, judges. I suppose we could say that judges have a lot of ethics, but one in particular is that they're to avoid controversy. And that implies some caution when they're engaging on questions of law reform. So, when in the course of commenting on a law reform proposal, we find 4 Chief Justices, along with other judges, expressing reservations, we know that something's up. Now, about this law reform proposal, we have the Chief Justice of Australia asked by the other Chief Justices to express their concerns. But from there it ramps up. We have the Chief Justice of Queensland saying that the proposal is not only disappointing, but disturbing. The Chief Justice of Victoria said it's troubling, and the Chief Justice of South Australia, going right out to the limits of judicial criticism, saying it's hard to believe that a measure like this could be proposed. Now, this is serious criticism, and I might say it's rare to find judges of this stature so unified in their criticism. The target, of course, was the legal profession national law, as it had been presented in outline and in draft at the end of 2009. Now, my facetiousness about the judges to one side. The judges, the Law Council of Australia, the Australian Bar Association, and the Rule of Law Institute did present a serious criticism of the draft national law. And this had a common theme. The national law presented a threat to the rule of law. Now, here I want to outline those concerns. I want to consider the revision of the national law afterwards, make a few observations about the value of this measure, revisit the implications that the redrafted, but still draft, national law continues to have for the rule of law. But first, some background. There is a lot of background to this. There's a large history in programs that are aimed at unifying the law and conduct rules for lawyers across the Australian Federation. These unifying projects, if we can call them that, have been conducted at 2 levels. Government has largely led the development of the legislation, and by that I include statute and regulations. The profession has wanted to control the development of conduct rules. Now, the first unifying stage, which we can call one of harmonisation, was the development of the model law and the model rules. Although it was the Law Council of Australia that initiated this stage, the Standing Committee of Attorneys General took control of the development of the legislation. And by 2004, they had developed model laws. Those model laws are a template for the legal profession acts that we find in all states and territories except South Australia. Contemporaneously with that process, the Law Council of Australia had developed the model rules, a professional conduct code for solicitors, and the Australian Bar Association had already developed the advocacy rules, a conduct code for barristers. Well, that was the first stage. The second stage, and the most recent attempt to achieve greater uniformity, still falls short of that. And this is really a standardising stage. It involves the same players. The Standing Committee of Attorneys General has been supervising the development of the national law, although it has been working through a task force chaired by Michael Lavarch, the former Federal Attorney General and former Dean of the QUT Law Faculty. The Law Council has been looking after the conduct rule for solicitors, and the Australian Bar Association the conduct rule for barristers. Now, so far as this project is concerned, there are two aspects of it that seem to me to have implications for the rule of law. There's the draft national law itself, and that's deservedly attracted the most attention. The Australian Solicitors Conduct Rule. The negotiations for the conduct rule, and to some extent the outcome of those negotiations, do suggest some challenges to the rule of law that emerge from within the legal profession itself. So, this is what we got at the end of 2009. This is what was suggested by the Lavarch Task Force, a regulatory structure for the legal profession. Everything would begin with the Standing Committee of Attorneys General, the Committee of Australian and New Zealand Law Ministers that we now call the Standing Council on Law and Justice. This committee would appoint the key national regulator, the National Legal Services Board, and the board itself would appoint the National Legal Services Commissioner. The board would also collect a number of roles that in the, at least in the eastern states, are spread across a range of regulators. It would be the single admissions authority. It would issue practicing certificates. It would make professional conduct rules. The Commissioner would have responsibility for audits and trust accounts, would receive all complaints, conduct all investigations and institute discipline. However, it was then envisaged that all of those roles except two would be delegated, would have to be delegated to state and territory agencies, such as the State Legal Services Commissioners, the Bar Associations, the Law Societies, and so on. The board alone, though, would retain the power to certify a person's qualifications for admission to practice law, and the board alone would make professional conduct rules. And it's the board that, on the whole, worry the judges. Now, this is a summary of the judges' concerns and other concerns that were added by other parties. The leading concern was the extent of executive government control over the regulation of the legal profession. And as a result of that, the loss of professional independence from government. It was explicitly identified as a threat to the separation of the judicial power from the executive. Now, the fact that the Standing Council on Law and Justice would appoint the board, the sole admissions authority and the sole rule maker, was of deep concern. Excuse me. Now, I've already noted some of the Chief Justice's responses to this, but the most comprehensive and yet I think succinct argument was given by our own Chief Justice, Paul Jersey. And this is how he put it. The importance of upholding, excuse me again, the importance of upholding the independence of the legal profession from executive government appears distinctly when the state is a litigant or claimant, which is the case for all criminal work and a lot of civil work. The other party to the claim may think it unfair that the executive government of the state delineate the framework within which that party's legal representatives may operate. With concern, naturally felt, if in fact misfounded, that the executive government would principally be doing its best to establish a framework favourable to the disposition of the business of the state. Now, it's worth unpacking and reflecting on that comment for a while. First of all, the Chief Justice is here presenting the independence of the legal profession as an incident of the independence of the judiciary. The emphasis is on litigation, criminal and civil. It's on the business of the courts. That, of course, is an important reminder to us. But I think it worth extending the importance of the independence of the legal profession to the work that is undertaken in legal advising, compliance work, and the creation and performance of transactions. But I'll come back to that. Secondly, the Chief Justice had a particular concern that the executive government not be seen to be in a position where it might be doing its best to establish a framework favourable to the disposition of the business of the state. So that suggests that whoever in substance might actually influence the composition of the board, his major concern is the mere fact that the executive appoints it. And thirdly, the Chief Justice hinted that the concern that the executive government might write rules to give it an edge in litigation might be misfounded. It's the appearance that's critical. Now, I'm not so sure that that concern would be misfounded. I'll return to that as well. A second set of concerns that judges raised was the language of the draft national law. It is permeated with commercial terminology. It describes clients as consumers, practices as business structures. Now, we hear this a lot, and I'm not so cold about lawyers recognising that they do run businesses. But a lengthy criticism of this was made by the Chief Justice of Victoria, Marilyn Warren. And the nub of her criticism was that the commercialisation of legal practice might itself undermine the rule of law. Too much emphasis on consumer rights, the pressure in commercialised lawyer-client relations for clients to challenge, and I quote her, the cost, language or accuracy of legal advice, placed pressure on the lawyer's role as an officer of the court. And with the board and the commissioner under executive government control, this risked even closer regulation by standards that responded to government expectations rather than to traditional standards required by the rule of law. Now, a third concern just peeked through the submissions, and in fact it was only found in the Rule of Law Institute's submissions. So thank you for that. The problem of over-regulation. At this stage, after the 2009 proposals, no one took this any further. Everyone just assumed that the Lavarch task force would deliver on its brief to introduce a scheme that gave effect to simpler, principles-based regulation. So, the task force made revisions to the draft national law. After these and dozens of other submissions were received, a final draft was given in September 2011, and this is what it amounts to. The intention is that the national law be in force on the 1st of July 2013. Effectively, what will happen is that the Victorian Parliament will pass the national law. And that statute provides for that regulatory structure. 3 new regulatory institutions are created. There is a new standing committee of Attorneys General or continue its own regulatory institutions to carry out the roles delegated by the National Board and the National Commissioner. These include the bodies that are to receive complaints, conduct investigations, audit trust accounts, issue practicing certificates. As the national law makes no provision whatsoever for disciplinary tribunals, each state or territory will also have to establish an institutional disciplinary framework. If any professional associations are to take on any of those roles, they'll also have to be given the powers to do so. And on the slide, I've noted the professional bodies or regulatory institutions that already carry out those roles in Queensland. Now, this isn't the place to consider the merits and demerits of the details of the national law scheme. But I do want to make 2 preliminary observations. First of all, there is nothing inevitable about this, about the adoption of the national law. In a fundamental way, we already know it won't achieve what was hoped for it. The term national law is now a misnomer. It isn't a national scheme in any respect. To date, 4 jurisdictions are still signalling that they intend to participate. New South Wales, Victoria, Queensland and the Northern Territory. The Australian Capital Territory, South Australia, Tasmania and Western Australia are not participating, or at least they've not indicated that they will participate. It's interesting that 2 of those, the ACT and Western Australia, are the only Australian jurisdictions that retain a self-regulating legal profession. South Australia has a system of co-regulation, and it is shared by the profession and the Supreme Court. Tasmania, like the eastern seaboard states, including Queensland, does have executive government involved in the regulation of the profession. So, it won't have national coverage. Further, the new institutions created by the national law are not created by the National Parliament. It doesn't have power. They're to be created by the Victorian Parliament and appointed by the Victorian government in a formal sense. So I think that it's actually more accurate to describe this as creating a standard law zone for the regulation of the profession. Now, that second observation has implications for the rule of law. The Federal Attorney General's Department plan for the national law was to secure, and I'm quoting, a lower regulatory burden on the profession through simpler, shorter laws and a principle-based approach. Lawyers complained about the length of the statutes that had implemented the model laws. We heard that there was a page of the Tasmanian Act for every lawyer in the state. Conduct rule development began with some professional associations, the Law Institute of Victoria and the Queensland Law Society at the least, moving to shorten the model rules to give principles of ethical conduct for solicitors. Now that's the national law. And I think that we can conclude that this aspect of the project has failed. The initial drafts of the national law were shorter, but not now. The table shows where we are if we're simply counting sections. It looks like the national law will be longer than the model laws. There are still sections to be added to a number of the schedules. Also, though, the national law reorganises the section numbering. For example, there isn't anything that is already in the model laws on trust account management that isn't also in the national law, but there are fewer sections in the national law dealing with trust account management. A number of the sections in the model laws are simply combined into one section with more subsections. It does look as though the national law itself is longer and more detailed than the model laws. And that isn't even including the application of law statutes that have to be passed in each participating jurisdiction, and that have to establish a whole level of state regulatory institutions. Something similar has happened with the conduct rules. The Australian Solicitor's Conduct Rule is longer and more detailed than the old model rules. The bar alone has resisted significant rule inflation, but even the bar hasn't managed to shorten the conduct rule. So with all of that background, let's return to the rule of law. And here I will refer to the work of a number of scholars that have helped to develop this account. As a young academic at the University of Queensland Law School in the early 1990s, Jeff Walker's Rule of Law was almost mandatory reading, certainly tactful reading. There are insights in that book that I'll come to soon. But I also want to draw on scholarship on the rule of law that has emerged in legal ethics, and specifically the separate work of Brad Wendell and David Luban. And since both Senator Brandis and Professor Ratnapala also mentioned him, I will also give my obeisance to Lon Fuller. Luban's take on the importance of lawyers' ethics to the rule of law is a reading of Fuller's morality of law as a morality of those who apply the law. Now, the term rule of law, of course, is a slogan, and it carries a set of ideas and assumptions, contested ideas and assumptions, that are more complex than its shorthand usage sometimes suggests. Now, as Professor Carney mentioned this morning, since classical times, the rule of law has been drawn in contrast to the rule of men. But as Luban pointed out, laws do not rule, and the rule of law, not of men, is actually a specific form of rule by men, including nowadays a few women. It is a rule of men and women by reference to legal standards and using accepted legal resources. And the men and women who rule are those who apply the laws. Judges, certainly. Public servants, yes, at times. And even more often, lawyers, especially when the lawyer is a counsellor. Wendell's and Laban's arguments are that the lawyer's importance to the rule of law is greater when she is engaged, in a counselling role, when giving the client legal advice, creating and guiding the performance of transactions, ensuring that the client complies with public regulation. What most lawyers do most of the time. The judges who expressed concerns about the National Law Project's implications for professional independence tended to emphasise the lawyer's role as an advocate in civil litigation and criminal defence. But much more in general obedience to the law, compliance with regulation, decisions about social and commercial behaviour is achieved in a true sense, voluntarily, and without any approach to the courts. And it is in a large way achieved through the counselling work of lawyers. Ordinary Wednesday afternoon document work in the office is the ordinary stuff of the rule of law. So as when judges apply the law, the predominant ethic for the lawyer as counsellor is his impartiality. So take legal advising. The obligation, and I would hazard the usual practice when consulted for advice, is to present the law as accurately as possible. There are conduct rules, especially those relating to conflicts, that hedge this duty. Rules that insulate the lawyer from any external influences of, say, more powerful clients that they might also have who've got competing interests, or from the influences of kickbacks secured through referral payments and commissions. Rules that discourage legal advice given to one client being affected by partiality to other clients or to the lawyer's personal financial interests. Now, the conflict rules naturally don't discourage the lawyer from partiality to the client. And that was one of Chief Justice Warren's concerns about the commercialisation of legal practice. But lawyers in the counselling role are often conscious of the unwritten ethic of impartiality that requires them to use the legal resources available to present the law as accurately as it allows. Where there are uncertainties, qualify the advice accordingly. But when discussing the ethics of legal advising, Laban gave a useful rule of thumb that some lawyers do use. Ask whether your advice would be the same if your client wanted the opposite result from the one you know your client wants. Unlike the lawyer acting as an advocate, when giving legal advice, the lawyer has no opponent to correct her presentation of the case. So we imagine an opposing interest so that the lawyer's advice is more judicial, impartial. Now that recognition, the lawyer engaged in ordinary Wednesday afternoon office work, is an example of the rule of law. That recognition enlarges our understanding of the importance of the independence of the legal profession. And it also means that we've got some lingering concerns about the effect that the National Law Project could have on the rule of law. First of all, it doesn't appear that the judge's concerns about executive control of the regulation of the profession have been completely addressed. Yes, the Victorian Attorney General has no discretion in the appointment of 3 members recommended by the Law Council and the Australian Bar Association, but the remaining 4 members of the board, including the chair, are appointed on the recommendation of the standing committee, the new standing committee, Executive Government. The sop to the profession, of course, is the power to veto the standing committee's recommendation on the chair alone. Chief Justice Jersey's point, though, was that executive government appointment of the board was itself the problem, and we still have that. But I think in addition to the Chief Justice's concerns, we have reason to be suspicious of executive government control of the profession. In this state, we have seen the executive government, to quote the Chief Justice, doing its best to establish a framework favourable to the disposition of the business of the state. In Queensland, under the Legal Profession Act, the executive effectively has the power to revise or veto professional conduct rules and to override them. And it has made regulations that exempt government lawyers from the professional conduct codes. Government lawyers can practice free of the particular constraints of the conduct rules that apply to all other lawyers. The second set of concerns relating to the commercial language of the national law also remains, on the whole, unanswered. Chief Justice Warren's difficulty with the National Law Project was that its emphasis on lawyers as business people, while that's understandable, accentuated the commercial pressures on the profession's role in maintaining the rule of law. But I think the problem here is more than the form of the proposed legislation. Through the negotiation of the conduct rule, the large law firm group pressed for rules that would allow simultaneous representation of clients whose interests conflicted, even if the clients did not give actual consent to that. That was fortunately resisted by other sections of the profession. But by the time the Law Council was prepared to open this to the public and released a draft conduct rule for comment, that draft conduct rule still provided for the possibility of representing clients with conflicting interests, even without their actual consent. Ultimately, it was the public comment that the Law Council received that led to its recommending a more traditional ban on acting for clients with conflicting interests, unless they give fully informed and actual consent. But I mention the incident because it illustrates one way that the legal profession itself can present a challenge to its own independence. The conflict rules are as much a protection of the client when the lawyer is acting as a counsellor as when acting as an advocate. They are buffers helping the lawyer to give impartial advice. As Chief Justice Warren saw, the commercialisation of legal practice has some capacity to undermine that. It is promising, though, that through the national law consultation, different sectors of the profession could see that, they could name that, and they resisted it. There is nevertheless one other risk that lawyers themselves present to the rule of law, and that neither government nor profession have resisted. And that is lawyers' inherent inclination towards legal complexity. The problem of over-regulation. It was merely mentioned by the Rule of Law Institute. It received no comment in other submissions on the national law. All participants in the process had agreed that shorter legislation, principles-based regulation, would be good things for the legal profession. But this is an abject failure. And one of the important contributions of Jeff Walker's book, The Rule of Law, was his warning that the rule of law was threatened by unrestrained legislating and the complexity of legislation. Excessive legal complexity undermines the intelligibility and the certainty of the law. Now, I'm not saying that standing alone, the draft national law and the conduct rules are a significantly greater threat to the rule of law than, say, the existing model laws are. But I am saying that the reduction of complexity that was promised by principles-based regulation was a welcome means of strengthening the rule of law, and the failure of principles-based regulation for the legal profession is something to be regretted. But we lawyers only have ourselves to blame. Regulatory theory has noticed that as a class, lawyers are predisposed towards developing more and detailed rules. Principles-based regulation, even in areas like financial markets, has been most strongly resisted by lawyers. By our training, lawyers try to minimise uncertainty and so minimise the flexibility of broader principles by closer drafting, putting forward more rules, putting forward more detailed rules. And we have done just that in both the development of the national law and the Australian Solicitors' Conduct Rules. So, in conclusion, the rule of law does to a significant extent, I think, rely on the rule of lawyers. And so long as that is backed by strong understandings of the lawyer's role and the ethic of impartiality that reinforces it, that's not really a chilling thought. That impartiality is secured by freeing the lawyer of external influences that might compromise the accuracy of legal advice, of counselling work, as well as of advocacy. However, the National Law Project promises a regulatory structure that risks that independence. And when we look at how the profession's independence is being put under pressure, yes, we certainly do need to take our traditional stance of being wary of the executive. But equally, we need to look closely at the pressure that we, lawyers ourselves, might also be putting on it.